We're excited to share something new at B&H. Whether you're in New York City, across the US, or around the world, we always strive to deliver that magical in-store experience to everybody online. Now we are able to bring that to you live. Magical in-store experience to everybody online. Now we are able to bring that to you live.
Recording in progress.
Good morning, leadership on the platform. I'm doing a test on my audio. I just want to check if I can have a sound. Thank you.
Loud and clear.
Perfect. Thank you.
Good morning, Alan. Do we correct?
Good morning, Chair. Yes, there's currently 8 members on the platform, so it forms a quorum, yes.
No. The video is. Welcome, honorable members. Welcome, to the stakeholders, the media, and the parliamentary teams. The meeting is officially open. Do we have apologies?
No apologies received, Chair.
Okay. We don't have apologies. And then let's move to the next item. Response by National Treasury and SARS to the submissions on the 2024 draft tax bills. National Treasury and SARS, over to you.
Good morning, Chair and honourable members. Duncan Peterson here, DG of the National Treasury. Chair, thank you again for this opportunity to engage with yourself and the committee. We have, of course, with us today teams from SARS and from the National Treasury, both on the policy side and on the legislation side, who will be taking us through the various items today. As we will shortly see, Chair and honourable members, in the presentation, the team will be taking us through the draft rates and monetary amounts bill for 2024, the draft revenue laws amendment bill, which includes, of course, giving effect to the two-part retirement system, the draft tax laws amendment bill, the draft tax administration laws amendment bill. And then we've got two bills, Honourable Chair and honourable members, that relate to the global minimum tax, both the tax bill as well as the tax administration bill for the global minimum tax. This is, of course, as part of the commitments announced by the Minister of Finance in the budget in relation to Pillar 2 of the global tax reforms. So, Chair, with your permission, I'll hand over to Chris, who's the head of tax and financial sector policy at the National Treasury, who's here with his team, and to take us through the presentation. Chair, I wanted to join, at least for the first hour of this meeting, to be with the committee as we go through these tax laws amendments. Thereafter, unfortunately, I'll have to excuse myself as we continue to finalize the work towards the MTBPS tabling next week, which we are finalizing this week, and which we'll, of course, bring to the committee next Thursday or Friday. So with your permission, Chair, I just wanted to be asked to be excused at 10 o'clock for my next engagement. Thank you, Honourable Chair. May I now hand over to Chris and the team?
Thank you, DG. Good morning, Honourable Chair, honourable members. We've got quite a lot of slides on the responses to the public comments on the bills that the DG has put forward. There are over 70 of them. We've tried to include as much detail as we can alongside the the response document. Just to note that these responses are draft. We haven't got approval from the DG, the Minister or the Commissioner on these. That's the regular case with the response document that we present to Parliament. There's quite a short time period between when the comments are made to Parliament and when we present on the comments. This also provides a bit of space for input from the committee on our responses before we make final decisions. So these aren't final responses on all of these issues, but we will try to provide as much detail in terms of our perspective on the comments that have been provided to us. With that, I'll ask Nhlanhla to please put the presentation up, and then we can start going through the different areas and the comments on the different bills. Thanks, Honourable Chair.
Chris, are you still there?
Yes, Nhlanhla, are you trying to talk? We can't hear you. Are you in the office again using your Wi-Fi? Sorry, Honourable Chair, we'll try and sort this out quickly.
Who's supposed to present? Is it Khadeb or yourself, Chris?
Nhlanhla's got the presentation he has, but it looks like he's struggling with the Wi-Fi. I can try and share it from my side instead. Okay, 1 second. Apologies about that. Is that coming up?
Yes, we can see it.
Okay, good. I'm great. And Nhlanhla, can you speak
Yes.
or?
Yes. Can you hear me now, Chris?
Yes, we can. Thanks, Nhlanhla.
Oh, okay. No, thank you. Apologies for that, honorable members and chair. We will then start the presentation with the draft rates bill, and then I will ask my colleague Mpho to take us through. Oh, but firstly, but just before, of course, then Mpho, are you ready?
Yes, I'm ready, Nhlanhla, yeah.
Okay, thanks, Mpho.
Good morning, Chair, and good morning, honorable members. I'll be taking you through the draft rates bill. The draft rates bill was first published on budget day with all the other budget documents.
Chair,
And in the draft.
Wait a bit. Is it Honorable Galek
is Maute, Doctor.
or as Mountain?
Chair, National Treasury must take us serious. It was the DG, Dr. Duncan, handed over to Chris. Chris and over to Nhlanhla. We wait here 5 minutes waiting for Nhlanhla to connect to tell us he's handing over to Mpho. What is that? Can the speakers just line up and speak? Those thing of saying I'm handing over, for what? We don't want to hear that. The speakers must just line up, Chair. They're wasting our time, these people. Hi. Thank you.
Okay, noted, Honorable Mountain. Okay, back to you, National Treasury. Try as much as you can to gallop. As you can see, your presentation is quite long, and we want to also afford the stockholders enough time to respond. Then honorable members also should also have enough time to respond. So our agenda is quite long today. So I'll request that you don't just read, you just speak to the slide. but make sure that you deal with the essential matters. Back to you, National Treasury and SARS.
Thank you, Chair. Basically, in terms of the race bill, we had increased the excise duty rates on alcohol, tobacco, and also on electronic nicotine delivery system. And we have received comments with regards to those increases and also some of the issues related to illicit trade in excisable products and also other administrative issues were raised in the comments. Now, in terms of the excise increases related to tobacco products, there were comments that the inflationary adjustments that we have made on cigarettes is not sufficient in terms of dealing with the affordability of cigarettes, considering that cigarette is the main tobacco product that is consumed, and that we should perhaps maybe have raised it to around between 8 to 10%. And our response to that is that the excise duty rates that are announced at that budget is not taken in isolation, but it considers all the other factors related to accessible products related to tobacco. Another comment that we have received was with regards to heated tobacco products, that the heated tobacco products should be treated the same way as cigarettes, and the excise rate applied to heated tobacco should be the same as a cigarette. And our response to that is that the structure that we have right now is an excise at 75% of cigarettes, and if there is any changes to the current structure, that will be subject to tobacco review process. And with regards to alcohol excise duty increases on alcoholic products, there were concerns that were raised that the current increases have taken the tax incidence way above what is currently there in terms of the policy guidelines, and that the excise should have been the adjustment should have been below inflation. And our response to that is that as a minimum, Chair, we have said that the excise duty adjustment will be at inflation as a minimum. So the suggestion that we should increase excise duty rate below inflation, we're not accepting that. And another issue that was raised was with regards to beer, that considering that beer is the dominant alcoholic product in the market, and also looking at the affordability of beer, we should be looking at increasing excise duty rate on beer much higher to more than 10%, so that we are able to deal with alcohol-related health burdens. We note that comment, Chair, and our response is that considering that beer is the dominant alcoholic beverage, and that in terms of alcohol content is also a dominant alcoholic beverage, that any policy measure that will take with regards to the adjustments of excise will consider beer in terms of dealing with alcohol-related harm. And then also with regards to the increases on alcoholic products, there were concerns raised is that the wine, only wine and ready to drink products are the ones that are passing through the excise duty increases, and other products or alcoholic beverages are not doing the same. And we note that, and we have always been saying that in terms of the excise incidence being above what is currently there in terms of the guideline, that the adherence to the policy guideline does not only depend on the annual adjustments that we make, but also on the behavior of the industry in terms of the pass-through. Because if the prices of alcoholic products don't increase, therefore the incidence will be exceeded. So the issue around the pass-through is quite important in terms of the excise adjustments that we make. And also there was an issue about that the increases that we have made have been unpredictable, and it has sort of like a disruptive impact on businesses, and there's a recommendation that perhaps in terms of the excise adjustment that we should be looking at a three-year outlook or adjustment of excise instead of doing it on an annual basis. And we note that comment, Chair, to say that to date the custom has always been that we make adjustments on an annual basis, but we are considering the proposal around having maybe a three-year outlook, and once a decision is being made around that proposal, the stakeholders will be informed around that, because there's an issue around certainty that the business is asking Treasury to consider when it comes to annual to this excise adjustments. And then also there was a view that the increases that were effected this that were affected this year, because they were differentiated. Specifically the wine sector felt that they were impacted disproportionately and without a justification. But we note that comment, Chair. But I think what is important to note is that the excise adjustment over the years have been focused more on hard liquor, what is referred to as hard liquor in terms of spirits, and the increases there have been much higher, and that has caused the widening gap in terms of the relative excise burden between the categories. So we're looking at some sort of narrowing that gap between the categories with regards to relative excise duties. And then there was also a comment with regards to electronic nicotine and non-nicotine delivery systems, which is more commonly referred to as vaping. We have made an inflationary adjustment, and there was an issue to say that since this tax was only implemented from last year June, that the increases of inflationary adjustment is not significant, because there's a concern that the youth are taking up vaping, and the excise duty should be much higher and all of that. And we note that comment, Chair, but since this excise duty was implemented last year June, it is relatively new in terms of the excise duty regime, and then we will be reviewing this over time, and will follow any developments in this area, and if there are any changes that needs to be made with regards to the excise duty regime, that will be effected. And then there was also another comment about the distinction between vape products that have nicotine and those that don't have nicotine. When we initially proposed an excise duty on these vaping products, we had initially thought of having a system where it will take account of nicotine content, but through the consultation process, the stakeholders felt that will increase the administrative burden of the system. So what we have done, we have implemented a simplified system where we don't make a distinction between products that have nicotine and don't have nicotine. So that concern has been addressed in terms of easing the administration of the excise on vaping. We don't make a distinction between those that have nicotine and those that don't have nicotine for administrative purposes. And there were quite a lot of comments that were raised with regards to illicit trade on excisable products that South Africa should sign the treaty with regards to the protocol on eliminating illicit trade on tobacco products, so that we are able to then to implement systems like track and trace, and also to cooperate with other jurisdictions with regard to dealing with illicit trade on tobacco products. And we know that comment, Chair, and the National Department of Health is a representative of government in terms of the WHO, and they are looking into that protocol. Basically, they are responsible for representing government and bringing this treaty to Parliament for ratification. That will help us in terms of then implementing all the requirements from that treaty. And there was also an issue that more money should be allocated to SARS in terms of the capacitating SARS to have more enforcement with regards to excisable products, specifically tobacco. But the comment focus more on having a ring-fence budget to SARS. And in the budget documents, the Treasury has made commitments around engaging with SARS on its funding challenges, and also additional monies have been made available to SARS with regards to capacitating SARS to build enforcement, and also to deal with issues around non-compliance in terms of the taxes that they administer. So the money has been made available already in terms of the commitment that has been made. And also with regards to other administrative matters that have been raised, Chair, the excise duty adjustments, they become effective on budget day as the minister tables the budget, and that has raised concern around the administration, the administrative burden that it places on the industry with regards to keeping of records up to that point when the minister tables the budget. Basically, it means that in that particular month of February, there are records leading up to the time the minister tables for the budget, and the records that need to be kept from that time up until the end of the month. That it imposes administrative burden on businesses, and especially small businesses. So there was a suggestion that maybe we should consider moving the effective date for excise duties to be to align with the fiscal year. We note that comment, Chair, and we are considering that proposal. And once the decision has been made around that, stakeholders will be informed around the changes to the effective date. Thank you very much, Chair.
Thank you, Paul. On the draft Revenue Laws Amendment Bill, basically this is an amendment stemming from 2023. Basically, we're trying to align and make some of the administrative burden that were highlighted last year to be much easier. So the key issue, I'm not actually going to go through this one. You can go to the next slide, Chris, on the comments. Thank you.
Okay, thank you. Maybe I'll talk to this one. So there have been quite a few comments on adjustments to the two-part system, policy adjustments. The system did come in on 1 September. There has been a relatively smooth transition to the new system. Some of the funds have been a little bit slow, but a lot of them were able to start taking withdrawals from their savings pot quite soon. In terms of the policy responses on this, some commentators felt that the 30,000 Rand that was put into the savings pot wasn't sufficient and needed more. They asked for a higher amount. Because this was once off, we didn't really have time to change that, but they have asked for, can there be further seeding amounts put into these accounts? We will look at those issues, but it is important to recognize that if we allow any further withdrawals, it'll be to put into those savings accounts. It will have some liquidity impacts on the funds. It won't be good for the retirement outcomes of those individuals. We are looking at it. Part of that is to say, well, can we now take the amounts that are in the vested pot, which is your previous retirement savings, and put them into the savings and the retirement pot, like a 2/3, 1/3 division. The same issues arise there, where there would then again be very large liquidity constraints for the funds because they would need to make large payments in a short period of time. It would simplify the system a little bit if that vested pot is being used up. But this is quite a big policy change, and we would need to think about it with quite a bit more care before making any announcements, and we haven't got any changes in this. Similarly, there have been proposals to use pensions for education fees or for further home loan provisions. Again, this is something that we can consider, but we're not making any potential changes in these draft bills.
Okay, on the technical matters, we received a couple of comments. One of them was to allow the optionality for over 55 because the funds have communicated to the members different versions. So basically, we have accepted that approach. We said we want to amend the income tax for the RLAB to cater for this issue. The other one was on the savings component, basically to it is suggested that the bill explicitly allow for the direct annuitization from the savings component at retirement. That one we noted, and then we said we're going to revert back to the version that we published in the 2024, in February 2024. The other comment we received was on the maintenance claims, that they should be deducted proportionally through various ports, and we said yes, that one we understand and we note that we will make some amendments on that one. And next slide, please, Chris. Then the other one on this one was should the retirement calculations be based on each contract or each fund? Then we said calculations for the minimum value to remain upon retirement are handled on per fund basis. I think that was one of the key issues there. The other one comment that we received was to say that members of the retirement annuity and the preservation might hold multiple contracts within the same fund. Now, so we need some wording. The suggestion was that the wording of the bill needs to cater for that. And we said accepted, we will actually make some of those amendments. The other comment we received was on the 3-year waiting period for the preservation funds members. We said accepted as well. A non-South African resident is still allowed to make a once-off withdrawal during his or membership up to the full value in the member's interest in the vested component. Thank you, Chris. Next slide, please. Okay, then these ones related to some of the matters that were not published in the previous versions of the TLAB. One of them was this unintended wording concerning the amount that members can withdraw, the 2,000 Rand in the savings withdrawal component, because it looked like the wording didn't allow that a member can take any amount that is less than 2,000. So we said the amendment, we take note of the amendment, and then we will amend the wording so that members will be able to withdraw any amount less than 2,000 from the savings component when they exit the fund. Another one was more about, it's more of a consequential amendment on the clarification of in the definition of a retirement annuity fund, because currently the wording says members' interest in a fund. Now, given that we have now 3 components, now it wasn't clear as to say what are we referring to. So in this instance as well, we will clarify the wording. Next slide, please, Chris. Okay, on the draft Taxation Laws Amendment Bill, and then I'll just hand over to Charlene just to take us through the carbon tax. Thank you, Chair.
Thanks, Nhlanhla. Good morning, Chair and honorable members. So for the carbon tax, we propose some changes to align some of the emission factors to calculate emissions with guidelines issued by the Department of Forestry, Fisheries and Environment. And we received some comments on this. We can go to the next slide, Nhlanhla. So the first comment is that when we change these factors in the schedules, there was a request that we should insert the range for certain values. So we've accepted that comment. The second issue related to comments on certain specific emission factors, for example, for coal and certain values, and there was clarity required on why these were not included in the schedule. In that case, this was not aligned with the guidelines, so we did not accept it. We can go to the next slide. We also provided a table which updated the fugitive emissions factors, and this was basically to allow for corrections in terms of applying a formula to determine emissions. And we made changes in the 2023 Tax Laws Amendment Act. There were comments from industry for us to align with the guidelines, and we've accepted this in order to make sure that the emissions are correctly calculated, specifically for coal mining and other activities. Thanks, Nhlanhla.
Okay, thank you, Charlene. Zalisile, on the next slide on the employment tax incentive. Zalisile?
Hello, Nhlanhla, can you hear me?
Yes, please go ahead.
Yes, thank you. Thank you, Honorable Chair, and thank you, honorable members. On the employment tax incentive, we had an issue there where there was a rampant abuse when it comes to the ETI. That involved training institutions that were claiming the incentive for students, but the students were not receiving the actual cash. And the reason why they were not receiving the actual cash, the employers were recouping the money from them with regards to the training costs. And we would know that our policy position when it comes to this generally is that employers should incur the cost for training, especially on the job training, and it should be in the employer's account and not the employee account. That has been the policy that has been there for quite a long time. We got comments that said they really support the measures that we have introduced to curb the abuse of the ETI. And we have now introduced a penalty regime, an additional penalty that seeks to basically try to encourage that employers comply with the ETI and that they are not taking aggressive mechanisms in order to claim the ETI. But it should be really pure and it should create sustainable employment, especially giving the youth an opportunity to have skills that they will be employable in the future. So we have introduced section 5.3 in the ETI Act, and most of the comments were, is this additional penalty going to apply separately to the penalties that are there in the Tax Administration Act? And we are saying that it is an additional penalty because we want to send quite a strong message to say that this is not acceptable. With regards to the anti-abuse, we got other comments that says that maybe we should introduce a monthly remuneration definition in section 4. Others were saying that maybe we should also look at promoters who are the creators of these aggressive schemes. And what we are recommending is that changes to section 4 of the ETI, especially when it regards to remuneration, because it's linked to a lot of other acts, for example, the Basic Conditions of Employment Act and other acts that are there, read together with the ETI, it won't be our recommendation that we make changes there because of we need to keep consistency in how the law reads and how it is interpreted easily. Thank you, Nhlanhla.
Okay, this one is more about the clarifying the anti-avoidance rules for low interest or interest-free loans. Basically, the question was more about the interaction between the Section 31 that talks about transfer pricing and the Section 7C. You see, but there was some concern that the current proposal may cause uncertainty for taxpayers that prepared a detailed analysis of the considerations that should be considered in terms of the arm's length interest rate. I guess maybe then the key question here was that if the TP is actually the transfer pricing rate is less than the official rate. I guess that was the main issue. But we're saying that this is a policy intent. The Section 7C of the Act is an anti-avoidance measure aimed at capping the tax-free transfer of the wealth. So that comment was not accepted. And then we can go to the next one, Chris. This one, yes, basically here what we proposed was the amendment to the definition of a connected person as it relates to partnership and foreign partnership, basically to exclude the qualifying investors. Then we received a comment. I think one of the major comments was to say maybe we really need to review the entire definition of the connected person as it dates back to 1962. And I guess maybe that is a bigger policy issue to look into it. And at the moment, we haven't accepted that. So we just stick to what was announced in the budget. Thank you, Chris. Then on the next note, this one, it's yes, I think these ones are still not accepted. Next one, Chris. Relation, yes. Unfortunately, Warren is challenges with the network. This one is in relation to investment in domestic, or the next one, Chris, yes. Yes, this investment allowance in domestic production of electric and hydrogen vehicles. I think amongst other comments that we received were to say maybe we need to add a definition of a motor vehicle. That one we accepted it because at the moment it doesn't, if there are no definitions of what you mean by electric or hydrogen powered vehicles, then no one knows. So we actually accepted that comment, and then we will add some of the definitions of electric and hydrogen powered vehicles. Next one, Chris. Okay, I think they're all almost the same. And then the next one, this one is just more of a technical correction. Inserting the word any. The next ones as well, Chris. Because these ones were just much more of technical corrections. One to say maybe the current wording didn't include, let's say, the foundations or supporting structures. So that wording needed to be added in the current draft, and we have accepted those ones. The next one, Chris. Well, then this one was to say that the scope of the tax incentive should be for all new energy vehicles, which include the plug-in hybrid electric vehicles and not only the zero emissions vehicles. And then we said not supported. A different support package for hybrid and plug-in hybrid electric vehicles is currently available through the APDP. So I think that was the answer. So we didn't accept that one. And then also, okay, maybe then there was, okay, the next one, yes, again, next one. There's so many comments, some of them. Next one. On the EVs. Okay, maybe this one. Okay, here the issue was to say the introduction of the Globe Pillar 2 could have an impact on the tax incentives. And yeah, I see that we did say we note this, and unfortunately, I think on the updated slide, I think it fell off there. But the key question, the response maybe here is to say, currently the Globe Pillar 2, the global minimum tax has the exclusion for substance-based investment. So maybe to some degree, we do take note that that might assist. However, maybe we might, there was a suggestion, I think even from PwC, to say maybe we must also look into the refundable tax credit method. Maybe I think in some of the countries are actually doing it, I think Singapore being one of them. But we do take note of that comment. Thanks, Chris. On the next one. Okay, on this one, the key one was that the impact of this accounting standard called IFRS 17 on the insurance contract. So because now the insurers have now started utilizing this IFRS 17, and most of the wording, because it's quite new and it's based on now the audited financial statement, to say some of the wording now needs to be aligned with IFRS 17. So most of the comments that we've accepted them. So on the next one, Chris. As well as this one, it's the same. Next one. Okay, now this one is more on the definition of rates. I'm not sure if Chris, you want to take us through on that one?
Yes, thanks, International. So on this issue with real estate investment trusts, listed real estate investment trusts get a special tax treatment where there is pass-through. In the draft Taxation Laws Amendment Bill, we did put in a clause that said once the unlisted property companies or unlisted REITs were regulated by the Financial Sector Conduct Authority, they would be able to get the same treatment. We have been having discussions with the Financial Sector Conduct Authority. A lot of the comments were saying that this would take a lot more time to get through because it would require the passage of the Conduct of Financial Institutions Bill and then additional resource allocations within the FSCA to regulate these entities. We are proposing that there is an adjustment in the Taxation Laws Amendment Bill to say that only when there are regulations put forward by the Minister of Finance which determine conditions within the regulations that can be verified, can these unlisted property companies then get access to the same treatment as listed property companies. So it would not be reliant on regulation from the FSCA. Currently, the listed companies also do not have regulation from the FSCA through the COFI bill because it hasn't been enacted yet. So this would put them on the same playing field. We would then publish draft regulations to identify those conditions to try and get the two entities to be as similar as possible. This is not meant for retail investment. This is meant for large institutional investors in unlisted property companies.
Thank you, Chris. Then the next one was on refining the definition of an exchange item for determining exchange differences. This one was based on certain financial arrangements that identified by SARS that include the preference shares that to some degree they were eroding the tax base due to the mismatches that was occurring there. So the amendment that came, the July version, we tried to say to the extent that that preference share is a financial asset in terms of IS 32. So we're using the accounting one. Now, however, we received that the wording now, I mean, to some degree, the comment was to say that we went too wide. So maybe we should just refer to preference shares defined in Section 8EA of the Income Tax Act. And I think that part is it's accepted. The next one, Chris. Okay, this one relates to some let's say holding companies that, because currently for the income tax, I mean, to be able to get a deduction or to be able to utilize your losses, you should be in a trade, you should be trading. So in these instances, there was a scenario that where now, let's say you have just a holding companies and it made a gain, it's not trading, it made a gain in year one, we tax it, year two it makes a loss, and then that loss doesn't get carried forward because the company is not necessarily trading. So what we're trying to do now was to try and address that. So And then some of the suggestion that came up was to say that we suggest that taxpayers be allowed to choose which given assessment, or within the given assessment, to either carry forward the net foreign exchange loss to the next year of assessment. And we accepted that because in any case, we are taxing them. Okay, on the next slide, Chris. This one is on foreign donor funded projects. Anissa?
Thank you, Nhlanhla. Good morning, all. Foreign donor-funded projects, the problem we had here was that in April 2020, we introduced legislation that said that every implementing agent that has a foreign donor-funded project must register such project for VAT as different branches. And the difficulty then arose that some implementing agents have 200 foreign donor-funded projects or more that they are dealing with, and it meant that they had to register over 200 branches, and it caused lots of complications in terms of administration and difficulties. So we then propose now to further amend that and require the implementing agent to have just one branch, register one branch. And the reason for registering it for VAT purposes is to provide it with the advantage of being able to claim back input tax credits where it incurs that on expenses, and to be able to use that money back into the project, because that's usually the requirement that the foreign donor has in terms of the contract. Next slide, please, Chris. So one of the comments was that the proposed amendment that we're amending to, that they have only one branch registration, doesn't actually address another challenge that they are having in terms of getting the approval from National Treasury, where we have to, before they register for VAT, they need to get a letter from National Treasury to confirm that this does qualify as a foreign donor project. And that requirement means that we as Treasury have to look at whether it qualifies as an official development assistance agreement. And yes, we do acknowledge that there have been delays within certain departments in Treasury in providing that approval, and we are working on that at the moment and finding a solution, because it is that solution is obviously dependent on human resources availability. So the other comment is that there are unintended consequences of this proposed amendment, in that it may trigger an output tax liability, because the VAT Act says that when you deregister for VAT purposes, they might be you've got to declare output tax as a deemed output tax liability. And so in instances where current existing, so if they have 200 and they have to merge it into one, it means they have to deregister 199. And that's the unintended consequence. So we did accept that comment. And what we're proposing to do in terms of the amendment now is to allow the ones that currently have many VAT registrations, if they want to continue in that respect, they may continue that way, because these projects are short-lived. They're usually sometimes a maximum of about 5 years. So it doesn't make any sense for them to deregister all of those, register it into one, and then the project will be ending anyway. And also to then assume, make the presumption that, sorry, Chris, about two slides before, the presumption, yes, this one. The presumption that that we're going to put, we're proposing to put in there is that if you deregister and choose to deregister and form into one branch, there will be no output tax liability. We'll deem it to be the one and the same. Next one, yes. So with regard to the proposed amendment on input tax claims, now the VAT Act allows vendors to go back 5 years and claim input tax credits that were not claimed in the past 5 years. Now, what we noticed was that vendors would sometimes deliberately not claim, and claim it in a future tax period in order to gain a tax benefit. And so the proposal was to say that if you have not claimed, then you must go back and claim in that same tax period that you were supposed to claim. Now, the comments were that this would lead to lots of difficulties, because firstly, those that file electronically, the SARS e-filing system is currently unable to accommodate this. And then there are also risks involved, because the adjustments would then need to be made manually, where people will have to go back to see which tax period it related to, and the manual adjustments could lead to risks of human error. So we've accepted all of these comments, and we've withdrawn the proposed amendment in the meantime to be able to consult further with all stakeholders. Thank you. That's the VAT.
Global minimum tax. Next slide, Chris. Basically, the global minimum tax is the one that where we're trying to tax some of the entities that are paying less than 15% of tax. So one of the comments I think that we received was to say there is that mismatch now, because let's say we have an entity now in the imputation with respect to the control foreign companies. So they are required to submit locally within 12 months after the financial year end the tax return. However, now according to the globe model rules, now we're saying the global minimum tax must be set within 15 months following the relevant financial year. So there is that mismatch. So what we recommend is that a South African resident taxpayer should reopen their tax return and then update only that foreign tax credit section with the additional tax incurred. That's one of the issues that came up. The next one, I think it was a big one for life insurance companies because there was that uncertainty as to whether the Article 7.5 of this globe model rules actually applied to them. We had a discussion as well with the OECD, and then we came to a conclusion that Article 7.5 can be made in these circumstances to cater for the life insurance companies. So I think that's the part that it was quite a big one there. And given the fact that while at the same time we're also going to wait for the OECD to try and update the commentary, maybe just to clarify this point as well from their side. But at the moment, we can still say that the Article 7.5 does apply to life insurance companies. Okay, then the next one, Chris. And then, well, there were some other comments that came up during the public hearings, and one of them was just to say, to some degree, there's no coordination, so to say, between DERCO and the National Treasury, and how do we actually, with respect to the role that National Treasury plays in that UN tax convention. I mean, the comment is actually misplaced. There is a coordination between DERCO and the National Treasury, and we actually work together on those ones, even on the decision making that came up as a result of that resolution that was taken in December last year, resolution 78 was 78/230. So there is a coordination. The other one that was saying that maybe the implementation of this global minimum tax might act as a barrier based on this UN tax framework work that is currently taking there at the UN. Well, it's not. Firstly, it's not. I mean, even the response there, it's not, because one of the issues is that if you look into that UN tax framework now, firstly, the proposals or the final protocol will only be finalized after 36 months. So next year, beginning of or maybe early February, there will be a meeting with the UN where they will be discussing where they'll be mapping the way forward with respect to some of the proposals there. So this thing might not take time. So South Africa cannot wait for another 3 years while other countries that have implemented these rules will now be actually eroding our tax base, because any of our entities that will be paying less than a 15% tax, that amount will now go to those countries while we're still waiting for the final UN framework convention. But we fully support it. That is the issue there. The next one was the next one, Chris. Okay, then the other issue was with respect to the effective date. And South Africa's intention to implement the GLOBE rules has long been stated in the budget documentation. And as well as that, implementing at a later date will mean that jurisdictions that have implemented the income inclusion rule will be in a position to levy the tax on income in South Africa, which is actually going to be quite bad for us. And then as well that, I mean, from the technical perspective as well, the tax under the global minimum tax is determined at the end of the fiscal year. And if the legislation is placed before that date, it is not retrospective. So, and then of course, then there is that 18 months allowance to file the relevant return. So there's still more time. And then the last thing as well that we just wanted to highlight was the fact that we are not alone here. Some of the countries, just like Australia and Canada, they're still finalizing their legislation in this regard. Okay, on the draft global minimum tax admin, over to you, Franz.
Thank you, Nhlanhla, and good morning to the Honourable Chair and Honourable Members. So this now talks to the administrative provisions around the GMT, or the Global Minimum Tax. And so the first set of comments were around the standardized return that is being used so that there's consistency internationally. The first point was that the document we were referring to was a specific document and we didn't cater for updates. So that's been accepted, and we're aligning that definition with the actual GMT bill or the money bill. And then there were some questions around the confusion that was introduced between the domestic and international context for the return. And again, we accept that, and we've made changes to cater for a separate approach for domestic and international returns. Moving on to the next slide.
Sorry, Franz, apologies. Just a quick one. Can you just raise your voice a little bit?
Apologies. Must be the headset I'm using. I hope that works. Right. So then there's a question around you have a situation where one entity can take responsibility for filing returns for the other companies in South Africa. And what you need to do is let SARS know 6 months in advance who this is going to be. And so the question was, well, do we need what kind of process? Can we have an informal process? We just send an email. Will you be using some kind of process using e-filing? And so those are operational issues that we will be handling, and those will be catered for under the Tax Administration Act, which applies here. There was also then a comment around clarity, which we accept, and we have proposed some amendments to assist there. This is then very similar to the comment Nhlanhla has already dealt with, which is that we have a mismatch. In South Africa, we allow you 12 months to file your corporate income tax return. And that's interesting because I can still remember when it was a shorter period, but in any event, as we sit here today, it is 12 months. And there's a 15-month or 18-month period to file your minimum tax, global minimum tax return. We accept that, but the key issue that would come into play here would be the tax paid, because the rest should all be following the ordinary process. And so there is the ability to make an adjustment to foreign tax credits if those are relevant. And so we're simply making that point. Next slide. Again, there's a question around notification. And so we reiterate the point that that's part of the operational implementation and would fall under the normal powers and procedures packaged for under the Tax Administration Act. There's a question around local filing. Again, we've dealt with that by changing the definition, so we think that would provide the sufficient guidance there. And then there's a question as to, well, in South Africa, if you have a South African headquartered group, is there a need to give us, as SARS, both an income inclusion rule return and a domestic minimum top-up tax return? And the answer is because of some of the transitional rules that are in place to assist in moving into the system, yes, that will likely be the case in the short to medium term. But as we move out of those transitional provisions, it may be possible to consolidate that into a single return. Moving on. Next slide, please. Thank you. All right. So there were some questions around the the ability to make a payment, and there's a lack of clarity there. So what we've done there is, in fact, accepted that. We've looked at the proposals and we have cleaned them up and aligned them further with the Tax Administration Act, so that there's a reliance on the existing provisions rather than trying to reinvent the wheel. Moving on. Okay, there was an issue around the penalties that are imposed. Here, that was proposed was a penalty of up to 50,000 Rand per month for failure. And so the first point was made was, well, should we not restate that and deal with it more consistently in this bill? The answer is no, because we are relying on the Tax Administration Act. But what we do accept is that some of the cross-referencing was confusing, so that we need to clean up. Additionally, the point was made that we should have better alignment with the provision that we are using in the Tax Administration Act, which in fact provides for an increase in the maximum penalty, depending on how much tax is at stake. And that is a fair point, and so we have proposed that that part be accepted. Then there seems to have been some confusion on some guidance that's been provided that says that if you've made reasonable efforts in the early years, you should not be subject to a penalty, and therefore we need to create some provisions that deal with that. The reason I say there's some confusion there is if you have a look at the provision, it says may impose, and that creates a discretion which is generally not available in the penalty provisions. And the reason we create that discretion is precisely so that we can take account of the fact that someone has made reasonable efforts to comply in this transitional period. At some point, it would probably be appropriate to change that may to a must so that there is full alignment. But in the early years, that discretion we believe would be valuable for the reason the taxpayers and commentators have put forward. The next and last point on this slide relates to the question of who should pay a penalty. And if you have multiple companies in South Africa and they're all required to file a return, you'll recall that one of the things you can do is you can nominate one company to file on behalf of all of them. And so the argument is now made that, well, if that one company then doesn't file, then you should only penalize that one company. But the fact of the matter is that none of the companies have complied. So, in fact, the penalty should be applied to all of them because they've simply appointed an agent to do the work on their behalf. That agent didn't do the work, but they retain responsibility for ensuring that it did. So we would suggest that not be accepted. We then get to retention of records and the extension of the period for reassessing. As the draft bill stood, those were both extended to 6 years instead of the normal 5. There have been some questions around whether that's practical. The fact of the matter, though, is that it is necessary because there is a provision in the model rules that means you need to check after 5 years whether certain things you have said in the first year are in fact correct and whether what you've projected has materialized. Now, since you're doing that after the end of year 5, if you don't have the records of what happened in year 1, it's not clear how you would in fact be able to do that. So you do need an extended period. And in fact, after having considered it, it makes sense that it's not a 6-year retention period. It should be 7 years because there is, of course, the 15 or 18-month filing period. And SARS obviously needs an opportunity to check that too if necessary. The point, however, is well made that because this happens in year 5, you don't need to have the ability to reopen year 1. So that aspect of it has been dropped. Moving on. All right, this is actually quite a simple one. There was a where applicable that was inserted in the draft bill. There were some questions about when it would not be applicable. That's a fair point. We accept and we have deleted the where applicable part so that it's clear the Tax Administration Act applies where this does not. The administration bill here does not. and I think we can move on. There was a question around the reasonable measures again, and here we have the response that we've already given. But there is a further point, which is that when you look at the implementation date, there isn't perfect alignment between this bill and the money bill, and that's a point we've accepted, and we have made the necessary change. With respect to the short time frame for implementation, as has been pointed out, there is an 18-month period from the end of the first fiscal year to file the returns, and so SARS will be following the normal process to get stakeholder input and do the systems around getting those returns in 2026. Right, moving on. We now have we now move into the TLAB. There was a proposal to adjust one of the part of the definition of a provisional taxpayer. It was pointed out that we ended up with a circular reference, and that's quite correct and has been corrected. On the value added tax. So when you import a service, we have what's known as a reverse charge. In other words, the person who receives the service charges VAT and pays it over to SARS, because the person providing the service may not be required to register in VAT in South Africa. Now, you currently have a 30-day period from either the earlier date of payment or invoice to do that. And there have been practical concerns raised around this, and so the suggestion was made that we change this to 60 or 90 days. So we looked at this and made it 60 days. Now we have two sets of comments around this. The first is, well, instead of looking at the invoice, you should look at when payment is actually made. So we did some international benchmarking, and from what we can see, that is not what other countries do. So the rules as we currently have them are consistent with international practice. Then there was the other one which said, well, thanks for the 60 days, but can we make it 90? And the response there is no. We looked at the examples that were provided to us, and those tended to focus on the filing periods. So we're just pointing out that you get the 60 days, plus you have the normal filing period. So in fact, it is a little longer than 60 days, and that again is in fact slightly more generous than some other jurisdictions. On this slide, there was a question around wording and consistency of wording. We take the point and we accept it, and the change has been made as proposed. So this turned around some measures that were taken to assist with people who don't have a physical presence in South Africa, but nevertheless have to pay VAT. And so the proposal was to assist them by saying, well, we can register you without you having to have a bank account, because we understand without a physical presence, it can be difficult to open an account in South Africa. But equally, we would like to at least have a contact person, or what we call a public officer, to be able to talk to. So we'd be looking for that. And so the point was then made, well, you have now included a provision that specifically says that if you get a refund, it has to go into a South African bank account. Isn't that inconsistent? And the answer is no. The reason we're introducing that is before it was never an issue, because if you couldn't open an account without a South African bank account, we didn't explicitly have to say that you couldn't get a refund except into a South African bank account. But the point is that if you have sufficient business activity and transactions in South Africa that you're now generating refunds, we think that it's then reasonable to expect you to have a South African bank account and go through the South African financial institutions, know your client, anti-money laundering, counter-terrorism financing procedures. And we then move on to the Tax Administration Act. The point was made that what we were proposing around the implementation of the Constitutional Court's decision in the Arena Holdings case made sense, but this was something that should also involve justice and constitutional development. We're pointing out that we did in fact have some consultation around this, but that we can withdraw this proposed amendment from this bill because there will be an omnibus bill that will include it, that will go through that process. Right. We now get into some fairly technical points. There is a question here around giving SARS the right to appear ex parte in judges' chambers outside of the High Court. And as we point out there, we believe the analysis there is misplaced. What we're doing here is we're proposing that a legally qualified SARS official is able to represent SARS in the High Court, in the Supreme Court of Appeal, or the Constitutional Court. And that's all we're seeking to achieve with that set of amendments. Also, what's happened here is there has been a recent court case, the so-called Poulter case, where it was held that in the tax court, at least, you could be represented as a taxpayer by someone who was not a legal practitioner. So that's fair, but equally, we believe it's reasonable that whoever represents you should be someone who is fit and proper to do so. And so the question then becomes, well, what is fit and proper? That is a term that is used in a number of pieces of legislation, and it's been interpreted in that basis. So we're suggesting that fit and proper is a term that's well understood by judges, and since the judge of the tax court is going to be applying it, there is no need to constrain their discretion by trying to narrowly define it. Moving on. That feeds into this comment, which is that we should use the definition in the Legal Practice Act. The point we make here is there is no definition of fit and proper in the Legal Practice Act. What they are, however, are requirements around codes of ethics, educational requirements, and so forth, and those would not be relevant in the case of someone who is not a legal practitioner representing a taxpayer. Then there's the question, well, what happens if the person who's representing the taxpayer is untrained? Well, it's the taxpayer's choice as to who this should be, but we make the point that there is this very important requirement of fit and proper, so that if you have someone who, say, has been convicted of fraud somewhere along in their lives or is otherwise unsuitable to represent the taxpayer, that is something that can be brought to the attention of the presiding judge, and then they would be ruled not to be fit and proper and would not represent the taxpayer. The point was then made, well, okay, what's the process then? And that's we would accept that there needs to be a process and that the dispute resolution rules would need to be updated once this legislation is passed, if it's passed. And so the proposal is then that that would go through the normal consultative process that we have for updates to the rules. Moving on. Then there is the last point here on this set of amendments, and that is, well, SARS is proposing that where a legal practitioner working for SARS appears in court, we would be permitted to recover costs as if we had as if that person were in private practice. And the question is, why would we want to do that? Well, if SARS briefs external counsel and attorneys, we win the court case, and as SARS's annual report for last year indicates, we win a vast majority of our cases, we are in a position to recover costs. However, if we are represented internally, which is the lower cost alternative, we are not in a position to recover costs. So there is an implicit incentive for SARS to brief external counsel because on that basis, we would be able to recover costs when winning. And we believe that sets up an undesirable situation. It also means that taxpayers are exposed potentially to higher costs because of external counsel, and therefore we think this is in fact a win-win situation because at the end of the day, it is the court that awards costs and will ensure that the costs that are awarded are appropriate. And we also point out that this is something that is not new in South African legal context. Moving on. One of the suggestions is that where you have a debt with SARS or you are applying for debt relief, SARS is in a position to call you in for an interview. There's some opposition to this particular proposal, so we've looked at that and partially accepted it, because when it comes to debt recovery, we can understand the concerns, and we think that's something that requires a little bit more thought. But when it comes to debt relief, this is something that benefits both SARS and the taxpayer, because instead of exchanging correspondence, misunderstanding each other's letters, we can have a discussion, resolve the issue over the table, and get it over and done with. So we're proposing that that aspect should remain, and that would speed up the process for both SARS and taxpayers, which would be for the benefit of all. We also point out that this right to call taxpayers in for an interview is hardly uncommon. You do find it around the world. Moving on. We now move on to provisions around estimated assessments, auto assessments, and original assessments. And so the first one was a technical wording issue, which we accept. The second one is, well, we need more detail here, and we're trying to point out the detail is available here. You just need to read the provisions together. And the last one is an interesting one, because it suggests the taxpayer can never voluntarily submit a return. We would point out that the concept of a voluntary return has existed in the Income Tax Act since 1982. And the reason it arises is you may have a taxpayer who is not required to submit a return because they qualify for one of the exceptions for submitting a return. But that taxpayer may nevertheless wish to submit a return to claim an additional deduction for some other reason. And so there is no requirement to submit the return, but the taxpayer feels it necessary to submit the return or wants to take advantage of a concession that the system allows, and therefore voluntarily submits the return. Moving on. This comment is a long-standing one. It's come up before as to why is the concept of auto-assessment taken up in Section 95. And the response there, which I won't go into detail, sets out the history and how, in fact, the nature of Section 95 has changed over time, so that, in fact, rather than being the avoidance and compulsion section, which is the language used by the commentator, it has in fact become a more balanced section. So moving on. All right. So those who have been listening to the Commissioner's interventions over the years will know that his objective is to move in the direction of dispute prevention, which is the ideal case where a dispute doesn't arise at all. And it's clear, though, that there are always going to be some disputes. And then the question is, how do you most efficiently resolve those? And so the Tax Administration Act currently allows for something known as alternative dispute resolution, which is a step before you go to court. And so the proposal here is to move that alternative dispute resolution, or at least enable that alternative dispute resolution, not only at the appeal stage, but also at the objection stage, which is the stage before you start the road to court. And we've had some conflicting comments on this. I mean, as you'll see from the first comment there is a comment that welcomes this proposal, thinks it's a positive step forward, and is looking for how the details, and we accept that. The details will be part of the revision of the alternative dispute resolution rules if this proposal is accepted. There is, of course, another school of thought which doesn't like it, which thinks this will simply delay the process, and we're trying to give some comfort to those who are of that view, because we're pointing out how successful alternative dispute resolution is. And we're making the point that it's completely voluntary. So if you are in the second school of thought and you believe that alternative dispute resolution objection stage isn't going to help you, then you simply don't opt for it, and you can't be compelled to follow it, and you can skip it. Moving on. Next slide. Thank you. Again, there's a comment around that this can be simply used to delay the process, and I've dealt with that already. There's a comment that we need to have clear, specific timeframes, and that's absolutely accepted. The dispute resolution rules will be updated as needed. And then finally, there is the question around alternative dispute resolution being headed up by independent arbitrators. And the point here to be made is that this isn't an arbitration process, it's a facilitated discussion. And the point also to be made is that that facilitator there are a number of requirements. So it may be a SARS official, doesn't have to be, but it must be a person of good standing with appropriate experience in tax. And this is the key part, it must be acceptable to both parties. So if one of the parties is not comfortable with the facilitator, they can say, no, they don't want that facilitator. So you're not forced to accept a facilitator that you're uncomfortable with. Moving on. This is a new set of provisions dealing around who represents a company. So again, this is generally welcomed because it provides a set of default rules. It also ensures there's a public officer when the company is created. And we just deal there with some of the misunderstandings that crept in and some of the issues that were identified, just to give some comfort to commentators that this makes sense. Moving on. All right, and here is an amendment that was not in the draft bill that was released for public comment, not in the parliamentary consultative process, but in some of the earlier workshops that were held with industry. The point was made that the tax board currently, and for those who are not sure what the tax board is, this is essentially the equivalent of the small claims court for tax, which deals with smaller disputes. That can only be chaired by a legal practitioner. That limits the pool of people who can preside in the tax board. And the point was made, well, there are tax practitioners, regulated tax practitioners who have deep experience, and they should also be in a position to preside at the tax board, which would mean that we could perhaps extend the jurisdiction of the tax board and have more cases go to that as a more informal, easier process to resolve tax disputes that don't qualify for ADR or where the ADR has failed. And the proposal here is to accept that, to have those tax boards presided over by either legal practitioners or registered tax practitioners. And I'll hand back over. Thanks.
Thank you, Frans. So there are a couple of other issues that weren't in the bills, but were raised in the public hearings. So there were questions about VAT zero rating and the review of administered prices, following on from the announcement of the president that we would look to expand the basket of essential food items and review those administered prices. So National Treasury is working on those, especially in terms of the administered fuel prices. We are liaising with the other departments that are responsible for some of those administered prices, as well as considering our own the tax impact on fuel prices. We are also doing research into the items to potentially expand the zero rating basket. We will advise the minister on those issues, and then he can make an announcement in due course. Those tax announcements are normally done at the budget, but it is up to the prerogative of the minister. And I think there is one more, Nhlanhla.
Okay, no, thank you, Chris. On the 12B one, we're still investigating. So yeah, we did take note of the comment about the 12B to say we haven't done anything yet in the draft TLAB. That's all.
Thank you very much, Honourable Chair. We're done from our side.
Thanks, National Treasury and SARS. Let's move to the next item of stakeholders. Each stakeholder will be allocated 2 minutes. Yes, each stakeholder is allocated 2 minutes to respond to the presentation by National Treasury and SARS. ADEC, are you there? Alternative Information and Development Center.
Yes, Honourable Chair.
Okay, over to you. 2 minutes.
Okay, thank you. So I think firstly, just thank you for the responses. I think it's very in depth, and yeah, I think it's covered a lot of the points that were raised. I think we just have one comment or question on the responses around the global minimum tax bill. So one of the points that we had raised was that the global minimum tax bill, it adopts the OECD's global rules by reference, and we had a concern about the fact that changes to this global rules and the administrative guidance on the side of the OECD would be automatically applied in South Africa without kind of a parliamentary oversight process. So we note that in the response document, the response is that the bill was updated to include clauses that enable the Minister of Finance to update the model rules and guidance to be considered in applying the global minimum tax, and that these updates will lapse unless approved by Parliament. But the thing that's slightly unclear, just in line of that, the wording is whether this update to the bill, does this mean that it's only updating the rules that will be considered and the provisions of the OECD guidance to be considered in the bill, that will have to be approved by Parliament, or is it also changes to the provisions that have already been considered in the bill that will have to be approved by Parliament? I'm not sure if that's clear, but I think that's all we have to say. Thank you.
Thanks, ADEC, and for keeping to the time allocated. Asisa, over to you, 2 minutes.
Good morning, honourable members. Firstly, thank you very much for Treasury for the responses to the comments submitted. From an ASISA perspective, we made various submissions on all of the different laws. And at this stage, it appears as if there were some that weren't addressed in the response documents. For those that we have seen a response, it will we will need the final responses and the final bill to assess whether our comments were incorporated, and where they were not accepted, we need time to analyze why and what our response to that could be. And if there are matters that need further clarification, we will engage with Treasury on that. Thank you.
Thanks, Asisa. Institute of Retirement Funds, Africa, NPC.
Thank you, honourable members. Thank you, Mr. Chair. From the Institute of Retirement Funds, South Africa, we made comments on the Revenue Laws Amendment Bill, specifically around the two parts. And most of the comments has been accepted. Thank you so much to National Treasury for that. There are one or two comments who have not been accepted, and we will also need to understand why and engage further. The one specific comment was around transfer to multiple funds, which was reduced to only allow a transfer to one fund. And we made the recommendation to that in the sense that we believe that existing rights are impacted, but we will engage further if National Treasury do have a different view on that one. Thank you, Mr. Chair.
Thanks. Next, SA Wine.
Thanks, Chair, committee members, and also to Chris and Mpho. We really appreciate your feedback. I think just taking 30 seconds to say the reason why we're sitting here is also looking at the budget, a medium-term budget next week. I think it's important to understand we would like to work together to see a 3% growth in our GDP. At least there's some silver linings from outside. There's greater electricity production, less load shedding, and then also the recent interest rate cuts. So I think we can also, if the economy is strengthening, it implies that tax revenue can also increase. And I think against that background, we would like to believe as wine, we add to the benefit of the country in terms of GDP, also looking at job creation, addressing unemployment. So in that regard, thank you to Mpho and the team pointing out specifically, looking at the market share of all these different categories, not wine specific in isolation, looking beer and spirits. So in terms of wine, we're sitting at our unchanged market share in terms of alcohol levels of 17% since 2005. Very important then also the manufacturers to pass on these excise duties as it's a consumer tax. That's really critical for us. And then in closure by saying we all need to understand what we're trying to do here is also bear in mind alcohol categories are consumed differently, and it will be dependent on the drinking occasion, the product characteristics, and also the consumer needs. But I think we've been heard. Thank you to the team, and looking forward that we can operate well within the incident rates of 11%, 23%, and 36% respectively. And we believe it will also be a CPI adjustment as we move forward. So thanks again for the opportunity. And if there's any other questions or more detail that's not in our submission or presentations, we're more than willing to engage further. Thank you, Chair.
Thanks. Salba.
Thank you, Chair, and thank you to the committee members for affording us this opportunity. We'd also like to thank Treasury and SARS for their feedback. Just a comment on the point or the response from Treasury about passing on the excise adjustment to consumers. Pricing is a decision that is taken by my members, so I can't comment on particular pricing, but I think our industry is a very competitive industry. Unfortunately, the competition includes both legal and illegal businesses, the illicit trade, which I referred to in our original presentation. It was one of the committee members, and we applaud that committee member, the honourable member, who recognises that consumers are under pressure and they will switch to illicit products. The research that we conducted in 2021, based on 2020 data, showed that even outside the sales ban that was effective in 2020, illicit products trade at about 43%. That's almost half that of the legal products. And yeah, in our listening in on the WHO presentation, the WHO also recognizes that the interplay between illicit trade and adjustments above inflation. And although they seem to think it's a matter that can be approved by improved tax administration, we respectfully disagree. Excise policy does indeed play a role. With that, I thank you, Chair.
Thanks. SAB.
Thank you, Chair. I just wanted to point firstly to the point that Mpho made around the competitive landscape of the alcohol industry, where the response in particular alluded to the fact, or maybe the presumption, that there is causality between market share and a rise or an increase in the harmful consumption of alcohol. And by implication that the competitive landscape of the alcohol industry, all else being equal, will result in a reduction of harmful consumption if that changes. So just as a principle, that is counterintuitive to the current excise policy structure, where the spirits rate, the spirits tax burden in particular, is higher than both wine and beer. And even though the market share, both on alcohol content and on volumes, is lower. So in that sense, and based on the rationale that guides the excise policy, the public health narrative remains that ethanol content guide the structure and the way in which excise increases take place. I would like to perhaps get a response on that, and when it is sometimes preferable to use market share, and when is it sometimes preferable to use ethanol content as a guide for the excise policy or the excise tax increase thereof, and what exactly are the principles that guide the excise policy and the excise tax increase if those are changing. We also like to say that so long as all alcohol categories pay excise taxes, the principle remains that they are all responsible for the negative externalities that exist and that arise out of the harmful consumption of alcohol. That being said, the impact and the implementation of the excise taxes are applicable to all alcohol categories, and that as a principle is that all alcohol categories should be taxed according to alcohol content. There should be no presumption about negative externalities being ascribed to one alcohol category when the drinking occasion says that all alcohol categories are interacted with by the consumer. So that needs to be clear by the response made by National Treasury. Secondly, related to pass-through, over the last 2 years, National Treasury has not asked for manufacturing detail, manufacturing pricing detail from SAB in particular. I don't know about other manufacturers, but we've always shared the average prices of SAB in good faith, knowing that both the rate of pass-through and the rate of tax burden is ascribed to the average weight of these prices. So just a response to the rate of pass-through, I would like to ask National Treasury, how are they calculating this without having asked manufacturers around the average weighted prices currently and into the future? Are they using third-party data? And if so, if it's still Nielsen, we know based on the excise policy that those are not applicable based on the assumptions that have been in dispute around Nielsen data. So I still think there is a gap around whether National Treasury is using the right data to determine costs. Thanks, Chair.
Can you summarize, Fadzane?
Yes, it is just in relation to making sure that National Treasury does use the average weight.
Please summarize?
Yes, that's the last point, Chair. Thank you.
Thanks. British American Tobacco, South Africa.
Thank you, Honourable Chair, and a big thank you to National Treasury for the comprehensive responses in respect of all the submissions made. At this point, I've got no further comments. Thank you.
Thanks. Vaping saved my life.
Morning, Chair. Morning to everybody in the committee. And thank you very much, Treasury, for providing a comprehensive feedback. Unfortunately, the primary question that we asked was what mechanisms are being used in order to measure the set goals by implementing excise tax on vaping products. Unfortunately, we are not aware of any mechanism that's in place, given the fact that the last time we conducted a National Youth Tobacco Survey was in 2011, and the first and only adult tobacco survey was conducted in 2021. Therefore, we've not been able to just identify whether there is an increase in vaping products or the sale of vaping products, particularly around the youth. And that answers to the question is what's presented in the document, that there is a fear that vaping products are a gateway to smoking cigarettes. We won't have that knowledge if we don't have a mechanism in place. We are also concerned that the current mechanism for the Global Adult Tobacco Survey doesn't look at the milligram strength of the nicotine that's being used. And the volume-based model, unfortunately, in our view, will manipulate this market and further entrench addiction, particularly in the most vulnerable parts of our population, the youth. So thank you very much, Chair. We're looking forward to a response to that.
Thanks. Kosato? Kosato, are you there?
Yes, we're here. We're here, Chair. We're here, Chair.
Kosato in the platform. Oh, yeah. Over to you. Comment, Matthew.
Thanks very much, Chair. Thanks, members in Treasury. Just quick thoughts from our side. I think on the issue of allocations for appropriations for SARS, we think we really should be much more aggressive than just simply giving $1 billion here or 500 million here. And our motivation, Chair, is to capacitate SARS with everything they need to boost tax compliance. They've done good work, but we need to increase tax compliance from 64 to 70% over the next 2 years to really help address the very difficult fiscal constraints facing the state and its ability to fund public services and boost compliance. Chair, then on our proposals, COSATU, with regards to the TLAB and the RLAB bills, we had raised issues, Chair, on the two-part pension reforms, which we think are quite urgent in some instances. They're not new. We've discussed them in the SCOP hearings over the past few years. And we think some are quite pressing. Number one, Chair, we think we need to resolve the issue of workers who lose their jobs, who are retrenched or dismissed. We think that should be resolved in the next tax year, because if a worker loses their job, they should not be in danger of losing their house or not able to feed their family, yet they've got money in the preservation pot. We think there is some ways we can find commonalities with Treasury, with industry, around approach in that regard. And it can be in the form of a monthly salary recipient. We do think, Chair, there's a need for discussion around allowing workers to transfer from the invested pot to the preservation and savings pot to help give further debt relief. But also we can do it in a way on a 2-to-1 ratio to boost preservation simultaneously. And we do think, Chair, there's a need to have some urgent discussions with the FFCA around caps on some admin fees, because we have seen some, not all, but some funds exploiting workers' desperation. Other issues we can discuss in 2026, education loans, tax reforms, etc. Chair, we do think, just wrapping up quickly, we think we need to set further tight timeframes around the VAT and fuel price reforms, because we've been discussing that since 2018, on and off. So we'd want to propose, Chair, that perhaps these discussions between Treasury, Labour, Business, and NEDLAC, both on the two-pot reforms and the fuel and the VAT reforms, that we should be required to report back to SCOF, whether it's quarterly, whichever makes sense, on those issues, and to see where can we find common sense consensus by the budget speech in February as well. So we wouldn't want to leave it open-ended, Chair. Let's give ourselves some tight timeframes that we will be required to report back to the honourable members about progress in these critical areas. Thanks, Chair. Thank you very much.
Thanks, Comrade Matthew. WHO.
Thank you, honourable members and Chair. Thank you very much for responding to our comments. We really appreciate them. Maybe just a very quick response to one of the comments that excise tax does matter for illicit trade, and respond that also the health benefits from excise taxes matter at least as much as the issue of illicit trade. That's why the focus has been to insisting on improving tax administration rather than foregoing tax increases. Thank you.
Thanks. Saika.
Doesn't look like they're on the platform, Chair.
Saika, not in the platform. Okay. South African Institute of Taxation.
Thank you, Honourable Chair, and to members of Parliament for this engagement, as well as to National Treasury for the very comprehensive feedback that they've provided in this regard. We do appreciate the opportunity to have had our submissions reviewed, and we acknowledge, based on a preliminary on the presentation and just going over the Word document as well, that there are a number of instances where our recommendations and proposals have either been accepted or partially accepted, which of course reflects a very productive nature in National Treasury's engagement with us in this process, and we appreciate the collaborative dialogue. We take into cognizance such amendments such as, the VAT prescription period for input tax claims, the Section 12H Roman numeral 2 with regards to suppliers by educational institutions, that National Treasury has heard our cries in this regard and withdrawn. So those and the others that have been discussed, we are glad about that. However, we do note that there are several proposals that were not accepted despite our strong convictions regarding the importance. Looking at the 7C and transfer pricing Section 31 interaction with regards to interest-free loans to trusts, and also if we look at the connected person definition in relation to partnerships, those were not accepted. But of course, we will review this in more detail and then of course provide further commentary, because we have to engage with this in a more robust way. But those are just our comments at this regard, and we'd like to thank you for the opportunity to engage.
Thank you. Old Muchwan.
Thank you, Mr. Chairman. We have two comments. I just want to start off by saying, echoing sentiments raised earlier, we are delighted with the comprehensive document that National Treasury shared. The two comments that I just want to raise in the interest of time is welcoming the proposed amendments to Section 23M, removing the responsibility on the FSCA to derive regulation and moving that over to the Minister of Finance. However, our only concern would be the timing of that. And secondly, what type of criteria would be imposed and how far back will these concessions go? On the second point, the definition of trust, the proposal to amend that to include collective investment schemes continues to concern us. As we've said before, these have significant implications, unintended consequences for CISs, and we do appeal to the committee to reconsider the stance on that. The one thing that is a little bit disappointing is that, on the trust definition, the document is silent. On 23M, just to go back there, we do note that the infrastructure projects is something that National Treasury continues to look at. Again, the timing of when that will be complete and whether amendments to Section 23M will include infrastructure funds at some point remains uncertain. Thank you very much.
Thanks. Asisa.
Thank you, Chair. I've already responded on behalf of ASISA for all of the submissions that we've made. I have nothing further to add.
Okay, no, sorry for repetition. Yeah, you responded, you were number 2. PwC.
Thank you, Chair. We thank National Treasury and SARS for the response and have no further comments.
Thank you. Sapua.
Hi, good morning, Honourable Chair and Honourable members. So I think from SAPOA's perspective, we are a bit disappointed. I mean, information is still a bit unclear. If I look at the taxation issues involving the unlisted property industry, the response that came from National Treasury said that, our comments were accepted, but there's again no effective date, there's no deadline, no clarity, who's going to assist the finance minister in issuing those regulations. So I think there's a lot more questions that's arisen from what's been put forward. And I think, going through the detailed document around that was distributed this morning around the clarification of the interest limitation rules, I think for us, I mean, it's clear that, you know, when we read that piece, that in 2021, National Treasury decided to make further changes to Section 23M, which became effective in the early part of 2023. And that was to reduce, that was in light of reducing the corporate tax rate to be revenue neutral. So we find it a bit difficult to swallow that, you know, that relief is given to corporate South Africa. And, you know, here we've got a issue where it's clear that innocent pensioners are trapped in the 23M rule unintentionally, which by National Treasury's own words was written in the budget review. So we just, we've been asking for this information for a while, is that we do want to understand why our recommendations to Section 23M subsection 6B was not considered at all as an interim measure whilst we wait for this new kind of long-term solution that's been proposed with the finance minister being involved. So I just want to say thank you. Cheers.
Thanks. Then let's move to the next item, committee interactions. Honorable members, there we are. Questions and or comments. Honorable Beasley.
Thanks, Chair. So just two comments. Is I think my concern is that the increase in excise tax, and I must state I'm not a drinker or a smoker, so I don't have a conflict of interest in this. But my concern is, and you raised it yesterday, that this increase we keep on putting on excise tax, we're driving illegal businesses. And I just think it's something we just need to be conscious of, is the more excise tax we put on these products, it's more the legality that's driving, and we need to come up with a way to stop that. And then I also am just Kasatu, I'm glad that we agree on something in terms of extra funding for SARS. And I think everybody agrees on that if we give SARS more funding, they'll be able to tackle this illicit trade and tax more, get more money for the revenue. Thanks, Chair.
Thanks. I don't see any other hand. Alan, from my side. Honorable Squad. Honorable Squad. Please unmute. Honorable Squad, can you please unmute? Honorable Squad, can you hear me?
Thanks, Chair. My gadget had frozen, Chair. Thanks, Chair. Chair, let me as well welcome the presentations that have been made by the team, but also welcome the inputs that were made by various stakeholders. However, Chair, on the issue of the issue of making the on excise duties adjustments, I wanted to raise a concern that as much as the Treasury might be agreeing to adjustment to be looked in a multi-year form, it might create a problem that in the long run, the same stakeholders will be crying that they're being targeted, because now if you set it at a time frame for 3 years for any adjustment, it might look as if it's a major adjustment that we have made, whereas it's actually minor. It's as normal and fair as you have been doing it annually. So I was just saying perhaps we need to look at the adjustment kicking in on or in that financial year, but we can give it perhaps a certain period for it to kick in, so that the stakeholders as well, or the end users of that adjustment, are able to prepare themselves. But for multi-year, for instance, if we were to say 3 years, you make an adjustment, that would actually look as if it's an exorbitant, and it might as well lead to the same issue or concern that we are raising, that we might actually push over, these people or most citizens towards the illicit or towards illegal activities or products that are not necessarily regulated. So I was just saying perhaps it's much better to leave it as is, but at least just make sure that we are able to give the end users a little bit time for them to be able to prepare themselves in terms of the effecting of the adjustment. Yeah, I think that would be that. And perhaps, Chair, to as well to Treasury to look at some of the global, for instance, the global minimum tax, to at least be able to give a time frame as to when can that be effectively implemented, so that even stakeholders are ready and they understand that as much as there might be other matters that are still outstanding that needs to be looked at, but this would be the time frame for that global minimum tax to be effected. Yeah, I think those would be my contributions. Thanks.
Thanks, Honorable Squati. Honorable Mauta.
Thank you very much, Chair. Chair, I only have 2 comments. The first one is on the presentation. I think the presenter was saying, he mentioned there's an issue of extension from 5 years to 6 years. And I heard him saying they've dropped that amendment. So I'm not sure whether dropping the amendment means they've abandoned their own amendment. So the amendment will not come through, or what does it mean? That's the first one. The second one, Chair, is, and you made this point even in the last meeting with the National Treasury on the bills, that the president made a pronouncement about the basket, but we're not hearing anything about that now here. All the energy is channeled through this thing, but nothing is been spoken about in relation to those additional items on the basket, which should assist the poor in these difficult times of our economy. So can the same energy be directed to that as well? The same energy that is directed to this must also be directed to expediting the finalization of the basket as per the pronouncement of the president. That's all from my side for now, Chair. Thank you.
Thanks, Honorable Mauta. Honorable Bateman.
Thanks, Chair. Echo the comments about the 0 rating and expanding those foodstuffs that qualify for the 0 rating, which has long been a DA policy. And may I also just ask that the Treasury take some time to look at the connected person definition around partnerships. That was something that was raised, and it probably needs a little bit more time and consideration and perhaps a little bit of dialogue. That's not to say that I'm saying that the definition is wrong, but I just think that the recommendation coming from a credible source just perhaps needs to be looked into in a bit more detail. Thanks.
Thanks, Honorable Bateman. I don't see any other hand. From my side, just to check from Treasury and SARS, When are you implementing the track and trace system? Because this issue that has been spoken about many years ago, and we raised it yesterday with the commissioner when he came to the standing committee to present the annual report. So when effectively will this come into effect? The illicit trade that seemed to be rising, more especially on liquor, cigarette, and so on. Do you have a plan as to how you want to deal with this challenge as government, not only as a treasury, but as government generally, including the law enforcement agencies? And also the issue raised about the excise duties, the above inflation increase. What was the rationale for National Treasury and SARS to come to that determination? Over to you, National Treasury and SARS.
Thank you, Honourable Chair. I'll start with a couple of the responses. Just to note, I mean, we can't accept all comments that do come to us. We do need to consider each of them, which is, we do try to accept the ones we agree with, the ones we don't agree with, we don't accept. On a couple of the points about the excise duties, the pass-through, we can look at that, look at the data that we receive and we are using. On vaping, you know, we said in the comments there that we had actually looked at an option where we wanted to include nicotine. That was our preferred option in the discussion document that we put in. But due to administrative reasons, we couldn't. So it was a call that went for a simpler system, but then it doesn't rely on nicotine. But we recognize that it might have those unintended consequences by doing so, which we had already mentioned in the initial discussion document. On allocations for SARS, that's noted. The two-part reforms, we are working and thinking of some of the potential adjustments that we can make. The one item on if someone has no income available at all, or no money in their savings part, no money in their vested part, but they've got something in their retirement part, and they've got no other income, and they've got no social security benefits, you know, there might be a good reason to them allow them some access to the retirement part, but only in exceptional circumstances. We are thinking about that proposal and the other proposal on the vested parts and transfer to savings and retirement. On the unlisted REITs issue, there are no timelines there at the moment in terms of the regulations. We will publish draft regulations which would look at those conditions and the timelines in terms of when it would come in. So further consultation can be had once we've had those draft regulations. This is about the adjustments in the primary legislation. There's a comment there about how far back they will go. I mean, this would be a forward-looking measure. Also note the comments on 23M, and we will look at that. The increase in the excise duties driving illegal business. I mean, our position for many years has been, we do try to take note of the illicit activities, especially in tobacco, but also in alcohol. And it does factor into what we do on excise duties, but it shouldn't be the driving factor. The driving factor should be enforcement. And that's part of why we had been providing additional funding to SARS to try and crack down on these issues. SARS can talk a bit more, I'm sure, about track and trace and what they've been doing. The timeframe for 3 years, I agree. There are some complications there. The global minimum tax, it would be effective for years of assessment starting from 1 January 2024. So there should be certainty there based on the comments that we've provided today. The announcements on the basket on the zero rating, you know, as we said in the slides, we are looking at that and we're looking at the levy. There have been discussions on 2018, since 2018. That's why National Treasury put in an independent panel to review the zero rating, and that panel made recommendations in the end of 2018, and then more zero rated items were introduced in 2019. We will update that work to then try and advise the minister. The rationale for why the Minister of Finance increased excise duties above inflation, that was partially a revenue requirement. There were additional revenue needed to be raised given the expenditure needs of the country. Alcohol and tobacco excise duties are one of the tax instruments that can be used to raise revenue, and it is up to the minister's discretion if he would like to do so, given these other constraints that are in the system at the moment. I think I've covered everything from my side. Mhlanhla, Warren, I don't know if you want to, if I've missed anything, and then we can pass on to SARS. Thank you, Chair.
No, thanks, Chris. I just wanted to highlight one of the comments that came up early with respect to the updates, whether they were still going to go through Parliament. The answer is yes. We actually do it exactly the same way as what we do for customs. So yes, any updates are still going to go through Parliament. Then there was some issue from the ERFA, the issue of transfers, and maybe we can actually look at it next year also. I don't know if it can form part of the Annex C, because I think we do understand that at some stage FSA may have approved some funds to do this transfers. So let's look at it again on that issue. And then the last one, what was it? On the connected person definition, and I think we agree. I think to some degree the definition of a connected person dates back to 1962, and I think even commentators as well, they do raise the point that maybe we need to look at it, and I think we take note of that point. Thank you, Chris. Thank you.
Okay, nothing from Iron France. Do you want to go for SARS?
Great, thank you very much. And so I think there are two here for me, and the one is around the question of the 6 years being dropped. So there are two issues here. What we were proposing was 2 6-year periods. So the one is how long you need to keep certain records for, and the other one was how long SARS had to go back to a previous assessment. And so we were proposing to extend both to 6 years. So normally to keep records must be kept for 5 years, and SARS has the ability to go back either 3 or 5 years, depending on what kind of tax assessment we're talking about. And so the proposal was to make both 6 years. So after we got the comments in, we looked at those provisions very carefully, and we reconsidered the model rules, and we came to the conclusion that records should actually be kept for 7 years. And the reason for that is that there are certain of the rules where you can claim certain kinds of treatment in year 1, but in year 5, you have to reevaluate the situation, and if certain of your assumptions didn't come through, you have to make an adjustment in year 5. Now, you'll only need to submit that return 15 months after the end of that year, which takes you into the 7th year from when the initial assumptions were made. So you would need the records in order to work out what the assumptions were that you made, how they've not come through or have come through. And so you in order to implement the rules, you need that information. And SARS would need access to that information to check whether that was correct or not. So that's why we're suggesting that it's not 6 years, it should be 7 years, to ensure that that information is available. Now we move to the second part, which was the extension of SARS's ability to go back and reopen an assessment. Because the adjustments are made in year 5, not in year 1, we don't need to go all the way back to year 1. We only need to look at year 5. So it's only the second aspect, which is the additional time SARS has available to go back, that we're proposing is not necessary, because the adjustments are made in a subsequent year So there's no need to go back to the very first year. So I hope that helps. On the question of track and trace, as you will see, it's seen in slide 11, there is an international convention that speaks to this, which South Africa has signed, but I don't believe is ratified yet. So that is a process that is outside of the Treasury and SARS space. And when it comes to an independent application of track and trace, I believe the Commissioner has made the point that track and trace on its own is not something that will solve the problem. It needs to be formed part of a much bigger set of interventions. So it's a useful component, but it is not in and of itself something that would solve the problem. And I suspect that's a point that he would have made again yesterday when the question was posed to him. Unfortunately, I was not there for that particular session. But I think that's the best I can offer at this stage. And I certainly hope I haven't contradicted anything the Commissioner said yesterday. Thanks.
Thank you, Chair. We're done on our side.
Okay. Do we have follow-up questions from members? Honorable Van Rijn.
Baie dankie, meneer Voorsitter. But also let me thank the response from National Treasury, as well as the follow-up engagement with various stakeholders. Chair, mine is not on the process that took place between National Treasury and stakeholders. Mine is mainly about bringing this process to its logical conclusion. I just wanted to confirm with the Secretariat of the committee on what is going to happen after this session, but also if what is going to happen will accommodate an impact analysis. Earlier on, I suggested that maybe the Office of the Parliamentary Budget should be engaged to give an analysis or maybe feedback on the envisaged impact on more especially of these muted amendments, for both our the transformation mandate, but also for the poorest of the poor, So I'm not sure if that will be accommodated or should parties do that on their own, because I thought it's important for us to have the possible impact of these muted amendments on our people, but also on our mandate as the government of the day. Thank you very much.
Well, thanks, Honorable Van Rijn. I think that was the last input. The issue of PBO will be attended to. They attend almost all the meetings of SCOF, and from time to time, they give advice to SCOF. And even right from the beginning, when the minister presented, tabled the budget, a day after the minister briefs the committee or the committees, the joint committees. After that, the FFC and PBO make presentations. We'll have to go back as to what was presented by PBO, and if there has to be an update, we can request them to do so. Before I close the meeting, let me check from the Secretariat. When is our next meeting to consider the report, Alan?
Thanks, Chair. So the committee set aside 2 days. That is the Tuesday, the 19th of November, and then Wednesday, the 20th of November. That's for the consideration and adoption of the committee reports and clause by clause deliberations on the bills. reason for the 2 days, it's 6 bills, so it's in all likelihood not going to be finalized in 1 day. Thank you, Chair.
Okay, thanks. And then our next meeting is when? Is it the lock-up session on Wednesday?
Chair, next meeting is Tuesday. That is the consideration and adoption of the committee BRRR report. Lock-up on Wednesday, and then briefing by the minister on Thursday. Thanks, Chair.
Okay. Okay, that does it. Let's close the meeting. We'll meet again next week, Tuesday. Thanks very much, honorable members, stakeholders, SCOF team, and everybody who's in the platform. The meeting is closed.
Thank you, Chair. Goodbye.
Thank
Long
you,
live
Chair.
Chair. Long live Chair.
Recording stopped.
Thank you, Chair.
The Honorable Chair, thanks, Honorable Members.
Thank you.